The New York State Comptroller's Office of Unclaimed Funds is pleased to present this video on voluntary compliance. This video will explain what is voluntary compliance, the benefits of participating in one of our compliance programs, who is eligible to participate, and provide a description of the two compliance programs offered by New York State. Reporting unclaimed funds is required under the Abandoned Property Law, or APL. Voluntary compliance occurs when a company that has not reported unclaimed funds in the past comes forth with the intent of reporting past due items to New York. Under Section 1412 of the APL, penalties and interest may be assessed on late or incorrectly reported items. Reporting under one of the voluntary compliance programs offers companies a 6-month amnesty period during which past due items can be reported without interest or penalty. Companies enrolled in a voluntary compliance program can perform an independent review of their records and will have access to a state auditor who will respond to any questions and aid the company in coming into compliance with state laws. Compliance also results in holders reuniting owners with their lost funds, which is good customer service. Companies are eligible for the voluntary compliance programs if they have never reported unclaimed funds to the New York State Office of Unclaimed Funds, or OUF, and if they have never been contacted about an audit of unclaimed funds owed to New York State. Some exceptions can be made to previous reporters on a case-by-case basis, such as correcting a previous mistake. Contact the Voluntary Compliance Unit, or VCU, for eligibility. Non-New York companies are subject to the New York State APL under Section 1312. Any unclaimed funds due to an individual or business with a last known address in New York State are reportable to New York under the decisions of the United States Supreme Court, Texas v. New Jersey. New York State offers two voluntary compliance participation options: the Self-Directed Compliance Program, referred to as the SDCP, and the Voluntary Compliance Agreement, referred to as VCA. The SDCP is a self-directed review done internally by the company or by a professional service provider hired by the company. By enrolling in the SDCP, the company will have access to an OUF auditor dedicated to responding to any questions. OUF sends SDCP invitations by mail to companies that have never filed a report, but companies that did not receive an invitation can request one by contacting VCU. Provide the company name, FEAN, mailing address, and contact person information to receive a letter and reference number. Completing the self-audit checklist with your reference number will serve as an enrollment application for the SDCP. The VCU will contact you by email if your answers indicate that you are holding unclaimed funds. The Voluntary Compliance Agreement, or VCA, is a formal agreement between the company and OUF. You will work with an OUF auditor on a plan to thoroughly review your company's books and records. You can apply for this option by submitting a completed agreement to the VCU. The agreement and instructions can be found on our website. A representative will contact you once the agreement has been reviewed. The OUF amnesty programs are voluntary. However, complying with the New York State APL is a legal requirement. Acceptance in either the SDCP or VCA is subject to approval. After completing either compliance program, companies are expected to comply with the APL going forward. Once accepted to the SDCP, the company completes a review of their records identifying all unclaimed funds and entitled owner information. Common types of unclaimed funds include uncashed vendor or employee checks, accounts receivable credits, gift certificates or gift cards, insurance payments, and bank accounts, among others. A complete list of property types is available on our website. General ledger properties reportable through the programs are subject to a 10-year plus dormancy reachback period. Next, the company completes the due diligence required under APL Section 1422, which requires a minimum of 90 days. Companies enrolled in the SDCP must submit their report and payment within 6 months. If additional time is needed, companies may apply for a one-time extension for up to 60 days. Extension requests must be submitted at least 30 days prior to the report due date. Companies that are accepted under the VCA will be contacted by an OUF auditor to develop a compliance plan. We hope that you have found this presentation informative and beneficial. If you have any further questions regarding the voluntary compliance programs, please contact our Voluntary Compliance Unit at nysvcu@osc.ny.gov.